Okay. All right. Hi, everyone. Thank you so much for joining us tonight for this workshop. This is the second workshop in our series. And earlier we heard from Alex, who spoke to us about just knowing your rights basically around arrest and early detention. What I'm going to be doing now is a little bit different. I'm going to be shifting towards folks' rights once incarcerated. And the audience that this workshop is intended for is legal advocates and those who are supporting prisoners. It will include more legal jargon and not so much of an explanation because there's a lot to be covered in this 101, but we do encourage anyone to stick around who might be interested in hearing about this. All the slides will be provided at the end of the presentation. And so there's going to be a lot of links throughout that will provide you with information that you could learn more about if, for example, it's not very straightforward as I'm quickly presenting it. And so this workshop is co-hosted with the University of Ottawa Law Union, the Criminalization and Punishment Education Project, the Black Law Students Association, and the University of Ottawa Prison Law Practicum. And my name is Lydia, and I am coming to you from the Prison Law Practicum as well as the Jail Accountability and Information Line. And I'm also a member of the Criminalization and Punishment Education Project. The Outlaws Student Association at UOttawa is also co-hosting this event. And I'm gonna just quickly start with a land acknowledgement, and then I'm gonna move into an overview of some of the topics that we'll be covering tonight. So as part of this land acknowledgement, I want to acknowledge that we are on unceded and unsurrendered Algonquin and Anishinaabe territory. I want to provide an opportunity for folks to inform and educate themselves about the different potential territories that you might be coming to us from. So if you're not in Ottawa and maybe you're not sure, you can check out this website that we have here, which is called nativeland.ca. And you can look up where you're located and see the different language and territories and Indigenous peoples who've occupied that land. We'd also encourage folks to take a moment and if you are financially capable, to make a donation to one of the sites that we have here. So we're going to be going over quite a few different topics tonight. What I want to do, though, is to sort of start and finish with some speakers. So we have Suhail Ben-Slimane here, who is a coordinator on the jail hotline in Ottawa. And then at the end of the presentation, we're going to hear from Rejan, who is a hotline coordinator with the Toronto Prisoners' Rights Project hotline. And so I just wanted all of this legal information to sort of be couched on either side with information about what the actual conditions are like in Ontario's jails and prisons right now, because they are quite horrific. And I think that it's something that we should keep in mind throughout the presentation. So it'll start with that and move into a conversation around the relationship between prison law and criminal law. And then we'll talk more specifically about the areas of prison law practice. And go into some of the barriers and best practices for prison law advocates. And then I want to talk a little bit about sort of ways to fund a prison law practice. So if you are a lawyer or a law student and you're thinking about sort of breaching into this area of law, just some of the different ways that you might be able to do it and also still stay afloat. And finally, we'll finish up with some different resources that are available to prisoners and their advocates and some different ways to get involved. So with that, I'm going to pass it over to Suhail Ben-Slimane, and he's going to cover sort of some of the different issues that we've been hearing at OCDC from the jail hotline over the last year or so.
Thank you very much, Lydia, for that. Sorry, I'm not going to be on camera. Yeah, so the Ottawa Carlton Detention Center is a provincial jail where almost 70% of people who are incarcerated are legally innocent, awaiting their day in court. there's people who are on immigration detention who are also held at the Ottawa Carlton Detention Center through like a partnership between the Ministry of the Solicitor General and the Canada Border Service Agency. There are people who are held there who are waiting to be transported, to a federal penitentiary because they are back on either they're back on parole revocation or they are just newly sentenced with a federal sentence. Um, with the um, with COVID-19 over the last year, uh, there have been several prisoners who have been either sentenced to a federal sentence or are on parole revocation that were forced and that are still forced to stay at OCDC for very lengthy periods of time because of how the Jewisville institution had an outbreak, etc., etc. There are also people who are sentenced to less than 2 years, although most people are sentenced to some form of provincial sentences. They are sent to other jails around Ontario. So those would be prisons, so provincial prisons, where people are sent to serve their sentences after they have been found in a remand center, like the Ottawa Cotton Detention Center. Um, Remand centers are very violent places where human beings are dehumanized and are violated along lines of identity, such as race, gender, etc. So people who come into OCDC, for example, like on the jail hotline, well, without the jail hotline, we just know that there are more racialized folks in maximum security prisons, Black, Indigenous, and other people of color, and people of color. And we know that they are more likely to be placed in higher security uh, places. They are also more likely to be assaulted by the guards. So there have been several instances during COVID where OCDC guards physically assault people. And that's due to, of course, just, the punitive and the violent nature of relating to each other on this planet, but also due to the added stress and anxiety that is created by COVID-19, both on the sides of the guards and as well of prisoners. So guards are working long hours because some of their colleagues are refusing to come to work. Um, they are more stressed out than before. Being like a guard is already a, you know, I guess a stressful job. Being a prisoner is even a more stressful, you know, a more stressful situation one can be forced into. But overall, the COVID restrictions at the jail, they created abhorrent violations, including the inability of people to defend themselves in court, including people having to segregate um, for 3 years just to have access to their disclosures because they're representing themselves, they're self-representing litigants. You know, there are several other violations that occurred during COVID-19 um, in relations to access to justice or like some form of justice, because to be quite frank with you, the courts, cops, and prisons are not justice, not at all. It's the opposite. There are systems of injustice. So to access some level of justice within our system, sometimes prisoners will come to seek assistance from their lawyers, only to be left uh, in the waiting room, the video waiting room, only for their lawyers to be left in the video waiting room without their client's presence. And bear in mind that 70% of people are legally innocent, and by not being able to talk to even your lawyer, there are several issues with that. Mainly, not being able to, build a meaningful defense that would, you know, uh, allow you to defend yourself in a court of law. Um, there are other several problems with the Ottawa Carlton Detention Center other than the legal problems, which range from issues with healthcare. So basically, we have a healthcare system at the Ottawa Carlton Detention Center and other sites of human caging that targets people, that victimizes people. Actually, we have a doctor that is a veterinarian. We tell it's not true that he's a veterinarian; he's a real doctor, but just how he treats people like animals. They treat us like animals. So, like, we think that he's a veterinarian. He's not really a doctor for human beings. Doctor suspends medication right, left, and center, with the help of the nurses on the floor, just because of suspicion of hoarding, for example. Like, they suspect you of diverting your medication, and just because of that suspicion, they will suspend your medication or dilute it in water, knowing that the medical staff are prone to error and people just want to verify what pills are they taking, but they're diluting water. That creates a lot of problems for prisoners who are taking those medications because, first of all, some of those medications that are diluted are slow release medications or extended release medications. And by crushing them, they tampering with the delivery of the medication, how it's supposed to be delivered to doctors. But hey, who are we? How can we speak on this? You're just a prisoners. You're just a prisoner, and your word is not, respected, and your humanity is not respected, and you're not viewed as a fellow human being. So, what happens is that prisoners plead through like the existing avenues, like I was explaining earlier in the other workshop. But the already existing avenues are super trash. Prisoners spend many years pursuing just some form of redress without having meaningful results. The processes are lengthy, takes so long, it's very complicated. You need support on the outside. Not everyone has support on the outside. While your rights are being violated on the inside, and you're basically, yeah, just like a sitting duck to carceral violence, and yeah, so um, just going off, continuing on the healthcare problems at OCDC, like we know prisoners, like human rights defenders and incarcerated activists who basically um, don't even have access to showers. They go weeks on end without having access to showers, because the guards, they said, oh, we either short staff, or the guards will tell the personal support worker, PSW, that the prisoner refused to come take a shower, etc., which is total bullshit. But they weaponize healthcare against prisoners in order to abuse them within the walls. So that's kind of normal. Um, the other thing to, you know, with healthcare is that folks who are disabled, so folks who are disabled at OCDC are, targeted even more by the healthcare system. They're not accommodated as they should be. We heard of cases where prisoners were not afforded, um, you know, personal mobility devices, although their disability kind of, forces them to use those devices, but the jail flat out refuses them, or sometimes when accepted to provide those devices, the prisoners were put in segregation and they were told that they can't be put with general population prisoners because the devices that they have metal in them. And because everything in jails, we have to understand that the state relates to its processes or creates its processes based on this notion of security. So human beings and human well-being is not really something that is, front and center for the attention of the state. So when they view humans, they see them as dangerous animals that are there in a human cage in order to like kill each other. So they don't even give them the devices that they should have that are prescribed by doctors. And I can go on and on, about what happened during COVID. Like, people eating sandwiches, swimming in pickle juice, people being assaulted, with injuries, being forced to stay in their cells for days on end, going to cells where there's like feces all over the walls that haven't been cleaned, prisoners dying in cells and the guards bringing other prisoners just like few hours after a prisoner was dead, laying there for hours. We can talk about the deaths that happened at OCDC due to overdoses because of the continued criminalization of human beings and drugs that they use. So I can go on forever, but I'm just gonna stop right now and I'm gonna let my colleagues take it from here. I wish you folks a great workshop, and I hope that we can share some knowledge that can be useful for each other. Have a great evening.
Thank you so much, Suhail. Yeah, I think that's really helpful. And I think it's a really important place to start from to understand the conditions that prisoners are living in right now, especially with the pandemic going on. And so before we launch into that, I just want to reiterate, that the conditions in Ontario jails and prisons are absolutely horrific. The things that Suhail just mentioned are very traumatizing, horrible experiences that a lot of the folks that we talk to on a regular basis are experiencing. And so it's important to have that in mind as somebody who is an advocate for folks who are experiencing these kinds of traumas, that your clients are going through a lot, and the really disproportionate impacts that these harms have on Black, Indigenous, and racialized folks needs to also be recognized in the ways that we approach these situations, especially as white legal advocates, to acknowledge our position and sort of the positions of privilege that often cause harm to other folks. And so on that note, I also want to acknowledge that for Suhail and I and others who work on the jail hotline and with CPEP, we approach this work from a position of abolition. And so our goal is ultimately to stop seeing punishment being used as a way to keep people safe, and instead to see more resources put in towards communities. And so as I'm going through these different areas of practice, I think it's important to bear in mind that that we're also looking at ways to approach using the law towards these goals of abolition. And in many instances, that's quite counterintuitive because the law is created to uphold, the criminalization and punishment of marginalized folks. So I think that one thing that just kind of needs to be addressed as an elephant in the room for a lot of law students and even lawyers is just like, what is prison law? There's not, some guidebook, there's not some manual, there's not just a specific set of rules or laws that apply in the prison context. Prison law is sort of like a mosaic of different areas of law being combined together to support prisoners. So when I think of prison law, I just say it's just supporting prisoners using laws that can support them. So some of the areas that I'm going to go over tonight are some of the main areas of law that have been used to support prisoners. So this includes human rights tribunal applications, internal grievance processes. And so these are very different when you're looking at federal versus provincial institutions. I'll also talk a little bit about parole hearings, healthcare advocacy, which in and of itself has another huge umbrella of different legal avenues that you might want to take. I'll talk a bit about different civil litigation that could be considered. And within that, we'll talk about some of the major class actions that have come out in the last 10, 15 years. We're going to look at administrative legal avenues, so things like charter applications, judicial review of administrative decisions within the prisons. This could also include something like a habeas corpus application. And then I'm going to talk about coroner's inquests, because sadly there are so many deaths in our prisons, which are a result of all the conditions that Suhail just talked about. And so there are lawyers who support families going through those inquests. I'm also going to briefly touch on international transfers, because there is legislation used to bring folks back to Canada or out of Canada who are incarcerated. So another sort of misconception around the practice of prison law is that you need to have a really good understanding of criminal law. And so you definitely don't need to be a criminal lawyer in order to practice prison law. Having a good understanding of criminal law definitely doesn't hurt. It's for sure a positive, but oftentimes criminal lawyers, that's their entire practice, and it's quite a time-consuming, fulsome area. And so to also do prison law and all these civil litigation files and potential human rights claims sometimes isn't feasible. And so oftentimes, and a lot of the prison law lawyers that I know do not practice criminal law. So the answer is no. But one thing that you definitely need to keep in mind, especially when you have a client who is awaiting trial, so they're incarcerated waiting for their hearing, is that you need absolutely to consult with their criminal lawyer before you take any kind of action. And even following certain cases, that could be quite important to do. So where somebody has any kind of active relationship with their criminal lawyer, you need to be cognizant of that, and you need to be in touch with that person before you do anything. In the context of COVID, it's particularly important. So a lot of the calls that we've been receiving to the jail hotline are with respect to conditions that are related to COVID-19. So like Sohail was explaining earlier, there's been staffing shortages where there's been outbreaks of COVID-19, and oftentimes the result is lockdowns. And so all prisoners are just put in their very small cells and not released for extended periods of time. And there has been litigation on this already. There's been a few class actions prior to COVID with relation to lockdowns. And so if you are talking to a potential client who's experiencing this sort of thing, it may be intuitive to say, okay, well, that's not okay. But what you want to do, especially if they're waiting for trial, is get in touch with their criminal lawyer, think about something like using these conditions as evidence at a bail hearing, or putting it towards sentencing credits, and making sure that they're also communicating this with their criminal lawyer as well. So before I launch into the different areas that I mentioned earlier, just some general best practices for when you're supporting prisoners as clients are outlined here. So an FOI is a freedom of information request, and an ATIP is an access to information. And so one of the first steps that you want to take as a legal advocate, if you are going to take someone on as a client, is to submit either an FOI or an ATIP. And this will give you access to all of the information that the institution has on your client or prospective clients. It's important, though, to be mindful that this takes quite a bit of time in some cases, and oftentimes the records will not be as complete as you need them to be. But it's generally the best first step, because as much as there are rules and policies in place that state that guards, superintendents have to provide copies of requests and of complaints, oftentimes they don't provide those copies. And even when they do provide the copies, we've talked to multiple folks who've had their cells turned over and all of their paperwork just thrown away. So you want to get that information for yourself as soon as possible. Where it's possible, and it definitely isn't always possible, it's good to establish a connection with a supportive friend or a family member on the outside, because one thing that we're going to talk about later on is all the barriers to accessing your clients while they're incarcerated. Like, this isn't a normal relationship that you might have in other areas of law, where you can just call your client and have them in for a meeting and quickly access information and evidence that you require. You're going to have a lot of difficulty even just getting a hold of your client. So if they do have a friend or family member that you can be in touch with, that'll be crucial. Like I said before, if they do have an ongoing criminal trial, you need to make sure that you're not doing anything that could impact that, because I mean, ultimately, of course, people want to seek damages and remedies for what's happening to them while they're incarcerated, but the criminal lawyer is the person who could hold the key to getting them out of there, and I think that for most folks that we talk to is their main priority, as it should be. And then finally, I just wanted to note that when you are talking to people who are incarcerated, like we were talking about earlier, it's really important to be aware that you might be the only person that they talk to for quite a long time. And so if you're, in some situations, um, they have a phone that they're rolling around to different solitary confinement cells, and you could be the only person that this person has contact with for quite a while. You also just might be the only person who they're talking to who's outside of that institution. So just to be mindful of how you treat your clients. I mean, obviously, you should always treat everyone with all the respect that they deserve. But in these situations, I think it's important for people who are interested in practicing prison law to take a bit of that extra time to have those conversations and to really listen. Okay, so the first area of law that I'm going to cover is the Human Rights Tribunal. So a lot of claims are made in the prison law context to the Ontario Human Rights Tribunal. I should also just note that if you are joining us from outside of Ontario, most of the information that's covered today is specific to Ontario. So I apologize if you're coming to us from outside. But one of the restrictions that we see when we're trying to access Human Rights Tribunal um, potential settlements or remedies these have to be made on a protected ground. And so, for example, if you have a client who is a white man who is not experiencing a human rights violation per one of those grounds, this isn't an option as a remedy for this person. But as we talked about earlier, Black, Indigenous, and racialized folks are far more likely to become incarcerated. Indigenous women are the fastest growing prison population today. And so oftentimes the clients that we're talking to will be facing some sort of discrimination, and oftentimes it is actually related to one of these grounds. And so some of the benefits of going to the Human Rights Tribunal are that it's free. So there's no cost associated with making the claim, which is very important because obviously access to finances is a huge barrier for a lot of folks who are incarcerated. But like most of the legal processes that we're going to talk about today, it's a lengthy process, and it will not provide support for immediate issues. And so that's one thing that's really tough about trying to access these different legal processes, is that they're quite time consuming. So I've provided a link here to the Jean settlement order. And this is a decision, not a decision, it's a settlement order, but it came out of a case that was raised at the Ottawa Carleton Detention Center after a woman suffering from mental health issues was left in.
Sorry, 1 second. I'll just put my mask. Sorry.
Sorry about that. So this is a case that came out of someone who was in solitary confinement for an extended period of time, and there's a list of recommendations that came as part of this settlement. And so it's been found to have been breached on several occasions, unfortunately, but it does provide helpful recommendations, and it is a good example of a success case for somebody who was incarcerated in Ontario. Next, I'm going to talk a little bit about the internal grievance processes. So they're very different in provincial versus federal institutions. And to say the least, the provincial grievance process is a complete mess. It's unreliable. It's not actually codified. And so there's very little accountability for it. What we see at the Ottawa Carleton Detention Center is the use of what we call blue forms. And so it's a physical piece of paper. It's a form. Prisoners don't have access to computers. They don't have access, they have access to basically what's like a Bell payphone, and occasionally a conference call phone if it's a call with a lawyer. But anything like a writing utensil to make the complaint, or like the physical paper to write it down on, the blue form, these have to be requested from the guards. And what's incredibly problematic is that a lot of times, if not all the times, the complaints are in some way related to the acts of the guards. So you're asking the person who you're complaining about to provide you with the form. And then they're supposed to give you a copy of that complaint. Oftentimes they don't. And oftentimes, even if they do, like I said earlier, if there's a lockdown, a search, you could lose that form. And so if your complaint is not resolved, or you're not okay with the remedy, you can go to the Client Conflict Resolution Unit, which is an oversight body where you can make separate complaints. Now, it's a bit complicated to say, but the CCR, this is something that you cannot complain to unless you can show that you've put in the blue form. So it's something that it's not an appeal. So you're not saying it's a whole new complaint, but you're not allowed to make this complaint unless you've already made a blue form complaint. So it's just an added layer. And then we have listed here the Ombudsman's Office. So we do encourage prisoners to call the Ombudsman's Office, and this is a potential avenue that you could use for more immediate sorts of complaints. So an immediate issue, like if somebody's in segregation and they want to get out as soon as possible, this could be an option. Unfortunately, though, in terms of more systemic issues, the Ombudsman's Office, while they do create reports, they don't really take any action on them. You also notice below the blue form, I have listed green forms. So these are ones that are specifically related to healthcare requests. And so I have a quote here on the right, which is from a caller to the jail hotline, just talking about how many forms they've filled out and how many times they've tried to access mental health supports. And oftentimes they're not giving them the forms, or they're just not being addressed. And then finally, I have here the ministry. So you could also make a complaint to the Ministry of Corrections. Now, what we often tell folks to do when we're working with them on the jail hotline is to just go all routes at once. Because it's kind of a crapshoot to know who's actually going to provide support. Oftentimes it's no one. And so when you're dealing with the internal grievance process provincially, we would often say, make a complaint, call the Ombudsman's Office, call the ministry. I don't have it listed here, but Kim Pate, who's a senator, she's often happy to be CC'd on these as well. And so just get it out to as many folks as possible, as immediately as possible. And then we'll often write a letter to the superintendent of the jail, or just an email, just to also inform them. And so we do have a report that should be coming out in the next week that details the processes that I just talked about. So if you check out the CPEP website, or maybe by the time these are uploaded, we'll have them there. And the federal grievance process is actually a lot more straightforward. The laws support it quite a bit more. And so I'm not going to go into too much detail into that one, but I have the link just provided at the bottom here for folks to check that out. Federally, the conditions are much better in terms of grievance processes, making complaints, having unions, because folks are there for longer than 2 years, right? And because they're not just there awaiting a trial and coming in and out like they are at remand facilities like OCDC. And so there are a lot more rights provided. So another area that's falling under this umbrella of prison law is parole hearings. Parole hearings are one of the only areas where legal aid will actually provide you with hours for doing the work. And so currently legal aid will pay for the entire hearing plus a 5-hour prep. What I have on the right here is some information from the Parole Board of Canada with relation to COVID-19. So what we saw at the beginning of the pandemic, not as much recently, was different and more flexible relations with the parole board. So I have a link provided here that can show, or that does show some of the different ways that folks were released and some of the different ways that COVID-19 was used towards that. And so we're hoping now that with the passage of time and sort of all of these release efforts being made, that this is something that could be continued. So if you are a law student or legal advocate and you're considering this avenue, I think this is a particularly good one to get into now, post COVID-19, because we have shown, or it has been shown that there are quite a few folks who are incarcerated who don't need to be, not that anybody needs to be, but there's definitely space and wiggle room that's kind of been opened up in the last year or so, and there's actual payment to do it. So you don't have to be asking your clients' families or turning folks down if you need the money. So something that folks might not be aware of is that in Ontario, you're stripped of your access to healthcare through the province when you enter into a prison or jail. And so you're stripped of your OHIP status. And essentially what happens, which Sahil was talking about earlier, is you're put into this institution and the institution has hired a doctor. So for example, at OCDC, there's one doctor and there's hundreds of prisoners. And this doctor is hired by the Ministry of Corrections, not a health ministry, right? And so your health care is taken out of health and it's put into corrections, which is problematic on a lot of levels. And there's been a lot of advocacy around that. And so if you want to see a doctor, you have to submit what's become referred to as a green form. And so these green forms, again, are you have to request the physical piece of paper, the pencil or the pen to write it, or not the pen, only a pencil. And if a guard, for example, like we've heard of guards saying, "Oh no, you're not that sick. You don't actually need that," and so you might be denied a green form, particularly with respect to like mental health issues, which obviously are experienced by many prisoners. We see this coming up quite a bit. In the federal context, if you're not able to access medical care, you would then go through the grievance processes. And so that's on the previous slide if you want to follow that link. We have in the past engaged with complaints to the College of Nurses and Physicians, because often what we're seeing at OCDC and different jails across the province is that the standards of professional care that nurses and physicians are supposed to be upheld to, they just simply can't be met in the context of a jail or a prison. And the staff are being overworked, and they're often doing this balancing act between security and healthcare. And it's always to the detriment of the prisoners. Unfortunately, though, with this legal process of making this sort of a complaint, it's a very long process, and your outcome isn't actually going to have a positive impact on the prisoner. I mean, it might in terms of being validated for their experiences, but there's no monetary award that could be issued to them. The only real recourse potentially is maybe recommendations for change, but those wouldn't necessarily be implemented. They don't have a legal status to be implemented in the jails. And so it's more just a punitive sanction against the nurses and the physicians, and one that we've sort of stepped back from in our practices. You could also potentially pursue a complaint with the Ombudsman's office. And that's, again, a good one for short-term kind of solutions. But ultimately, where there's a major physical harm done, you may want to consider civil litigation, which I'm going to talk about a little bit later. But unfortunately, as folks know who are in law, it's really difficult to claim until a serious harm is done. And so oftentimes when you're talking to somebody, it might be in the process of the harm being done. And it's not until they've really suffered that they would have, grounds or a claim that would be like helpful to them and not just cost them more money than it's worth. So we have an open letter from CPEP and the Prison Law Clinic that's coming out shortly. And so, I encourage folks to keep your eyes peeled for that. And I also do have a link here at the bottom to a zine that was recently created in Ontario by medical care workers around supporting people who are incarcerated. So, like I mentioned, a lot of civil claims come out of the prison law context. These are usually for negligence relating to issues around healthcare or physical health of prisoners. Sometimes we talk to folks who have experienced some serious neglect. Other times we talk to folks who've literally been physically assaulted by guards. And so the example that I often talk about, which is a little bit graphic, so give a trigger warning, I guess, is, talking to someone who had their ribs, told me that they had their ribs broken as a result of an assault by guards. And so when I heard that, I was really shocked and I was upset, obviously. And so I thought for sure there's got to be some sort of a claim available. And I mean, there is, but the issue is that it costs money to put forward a claim, right? And so the courts generally assign sort of like almost monetary values to harms done. And so having your ribs broken isn't really worth that much, which sounds awful. But the costs of a claim and the time that would go into it, like hypothetically, if a prisoner was to pay to file the statement of claim, that costs money. For the time that the lawyer would spend working on it, that would cost money. There's no legal aid certificates for this kind of thing. And so what they would actually get out of it at the end of the day might be a couple $100s. And by the time they've put all of that money into filing the claim, there really is no cost benefit to it. So when we look at these civil claims, it's really unfortunate, but oftentimes it's not until a significant amount of harm is done that the law really becomes of benefit to folks who are incarcerated. And so those things need to be considered, and it's horrific, the things that people will tell you, and the ways that you'll have to sort of navigate whether or not this is a viable path for them. And so further sort of complicating this is the Crown Liability and Proceedings Act, which recently came about. And so this is something that the Ford government put forward, which seriously impacted negligence cases that are being brought forward against the Ontario government. And so this is a pretty serious blow to folks who are trying to advocate for people who are being negatively impacted by the government. Fortunately, there's a recent decision just this year which dealt with the use of segregation for folks with mental health issues. And so the courts dealt with the Crown Liability Proceedings Act with respect to systemic negligence. And so this was a somewhat positive decision, but there still is a bit of a flux right now. So we're not too sure where things are going to land in terms of whether or not civil litigation and liability of the province is something that we're going to have to consider. So that's a whole nother area that I won't get too deep into, but it's also important to consider in a civil claim whether a class action might already be in progress. And so right now there's a number of class actions that are ongoing with respect to conditions in Ontario jails and prisons. And another consideration that you might want to make is whether or not, as a lawyer, you would be able to start a class action. But oftentimes, unless you're working with a big firm that is doing these on a regular basis, like if you're a sole practitioner, just the administrative costs would probably not make that possible. But I've provided here a list of some of the ongoing class actions in Ontario. And so again, these slides will be provided afterwards because I recognize that this is probably too small for anyone to read. But there are a number of ongoing class actions. And so before you kind of take something on, you'll want to talk with your client and see maybe if they're already encompassed by one of these. Although it should be noted that the class action, the class periods, they always have an end date, right? And so in a lot of situations, by the time a class is actually certified, that end date has long passed. And so many folks will, if they're currently experiencing an issue, they may partially be covered by a class, but probably not entirely. So one of the largest areas of law, or with the most sort of pieces under the umbrella, I guess, it would be administrative law. And so, again, it's really important to assess whether your client is awaiting trial or not, because this will have major impacts on how you want to navigate certain avenues. And whether or not, like, for example, a charter application or a habeas corpus application, these, if somebody is awaiting trial, may be raised by the criminal lawyer in the trial or sentencing process. And so if you're not their criminal lawyer, that would kind of be out of your hands, and you might want to offer to support, but it wouldn't be for you to raise. So a habeas corpus application, though, can be raised at any point in time. So this could happen in the trial process. It could happen much later on. And so it's important to note, though, that the remedy for habeas corpus is not, there's no monetary remedy associated with it. It's just release from the conditions that are found to be unfair. And so this could be, for example, somebody who's in segregation. It could be them being taken out of segregation. It could also relate to a transfer. So if somebody's in a minimum security facility, and then they're transferred to a maximum security, and it's a punitive sanction, and you're able to distinguish that, then they may have this option. However, you want to make sure when you're talking about this with clients that they don't expect to be fully released, depending on what kind of application you're bringing forward. Although it could be an option, so that's important to consider. Charter applications, so Section 7 and 12 are two of the most common in the prison law context. So again, it could be something raised in the criminal trial or later on. And then sort of under this massive umbrella of administrative law, you could also be looking at reviews of administrative decisions within prisons for access to, for example, like reading materials or just access to different external supports. And so generally though, for a lengthy process like a judicial review of an administrative decision, it's not going to provide an immediate outcome. Very rarely will the law do that, but it's going to be extended, and it's something that we see more in the federal prison context where folks are there for a lot longer. And then finally, I just have a note on international transfers under the ITOA. So that's the International Transfer of Offenders Act. And so this is something that can be used, for example, where clients have been detained in the United States. And oftentimes we'll try to have them brought back to Canada and just kind of citing all the really awful conditions that are specific to the States. And working to have them brought here closer to their families, because serving a sentence in another country is obviously incredibly difficult. And so, these applications can be brought forward, and they used to be a lot more difficult, but they're becoming more accessible to folks. So finally, I have up here coroner's inquests, and I should note this is not an exhaustive list. So as I stated earlier, prison law is just helping prisoners using the law. So whatever means you can think of to do that, that's prison law. So finally, I have here coroner's inquests, and so as I mentioned earlier, and Sohail had alluded to as well, deaths while incarcerated are incredibly high. Your likelihood of dying in jail is exponentially increased when you set foot in those doors. And so one of the ways that legal advocates can support families and friends afterwards is to represent them at coroner's inquests. And so a coroner's inquest is not like a criminal trial in the sense that you're trying to assign guilt. It answers questions about what happened and looks at ways to prevent that from happening in the future, which can bring it can bring a lot of hopefully support to the family if they want to be a part of that process. Obviously, families don't have to be a part of that process. So what they can do is apply for standing. And so when you do apply for standing, you can also apply to be reimbursed for your legal fees. And this is something different than a legal aid certificate. This is done with the Office of the Chief Coroner. And so I've provided a link at the bottom here. And so the legal fees can be reimbursed for up to 9 hours a day, and then 2 hours of preparation time. And so this is one way, another way like parole hearings, that if your clients don't have finances, that you can finance it through other forms of funding. And so in this process, if you were the legal advocate, you could bring evidence. There's 5 jurors, and so you'd be speaking to the jury and seeking different recommendations. These are open to the public as well. So this is just another way to sort of support prisoners and their families. And so I wanted to talk about solitary confinement just as an example. Oh man, sorry for the typos. And so this is an example that just kind of shows that there's so many different ways that you could approach a given problem. And so we've seen solitary confinement raised in civil litigation. So the Francis decision that I was talking about earlier, that was a class action that was looking at systemic negligence through the use of solitary confinement of folks with mental health issues. That application also brought forward charter infringements. It was a class action. We've also seen folks use habeas corpus through administrative law around solitary confinement, so to have folks removed from solitary. This is also something that can be brought forward before the Human Rights Tribunal. So if somebody is placed in solitary confinement, it's related to a mental health issue. So the Jean order that I was talking about earlier, that's a case that stemmed from Christina Jean being held in solitary confinement for such an extended period of time. And this could also take place through healthcare advocacy. Prisoners can bring green forms to try and see someone to have them released. We could also make complaints. Again, as I said earlier, they're not incredibly effective when you're making the complaints to the College of Nurses and Physicians, but this is one case where or solitary confinement is just an example of a situation where you would want to like look at all of the options that you have and really assess what is the best for your client, right? Like think about whether or not they are covered on a human rights ground. So are they being held in solitary because of ongoing mental health issues? Think about whether or not they're still in a trial process. How might this impact their criminal trial if I start advocating for something? And then consider, the case law that exists. Now we're looking at with civil litigation, the Crown Liability and Proceedings Act. So we're going to have to look at these sorts of things, whether or not this person might be covered by an existing class action. There's a whole sort of analysis that you have to do to go through all these different areas and then really think about what's the best for your client and their situation. So as I mentioned earlier, prisoners are, incredibly difficult to represent in the sense that it's difficult to even be in contact with them. And so the inability to communicate is a massive one. And it's something that we've seen as a huge barrier in our legal advocacy with the prison law practicum. Just even getting consent forms signed, especially in COVID times, we can't go and see them. And so trying to send them in and have them sent back to us takes an incredibly long period of time. We can't make ingoing calls, so we have to rely on folks calling us and that we're able to answer the phone when they call. The phone's cut off after 20 minutes, no matter what. And so if you're thinking about taking on prison law as part of your practice and you want to be supporting folks who are currently inside, it's really important to think about that because you're not going to be able to talk for a long period of time. When you have a meeting with your client, you need to make sure that you're absolutely available to take that call because they might not be able to call you again and you're not going to be able to call them back. They can't call anywhere with a switchboard. So if your line requires you to dial 5 as your extension, you're not going to be able to be easily reached. Again, the use of lockdowns and segregation will have a massive impact on communication. So while folks are being locked down, they're not allowed use to the phones. And then these conditions as well, just really, really bear that in mind that the conditions in jails and prisons are absolutely horrific. So your worst day is probably a great day for your client, right? Like you really need to sort of check that privilege and really be aware of the traumas that your clients are experiencing every single day. And then, we've already kind of gone over this as well, but the ability to record what's happening and keep sort of documentation is entirely stripped away from prisoners. Just plugging in my laptop. Just bearing that in mind that you may or may not be able to access any of the documents or the evidence that you need and really assessing the quality of your case without that information and trying to be creative about ways that you can access it. So as I mentioned earlier, parole hearings are one of the only things that are still funded by legal aid in terms of prison law support. All the other areas that we went over earlier are generally not covered by legal aid unless, for example, like the Human Rights Legal Support Center may take on a certain case, but currently they're incredibly backlogged and their phone number is, we've tried to help prisoners get through to it and they've never been able to stay on hold long enough to get past that 20-minute marker. And so in 2019, Legal Aid Ontario launched what they call the Prison Law Strategy, and I've attached a link to the PDF report that came from it. And it outlines a lot of the conditions of confinement that I've talked about today, and it's a helpful resource, absolutely. But unfortunately, directly after the launch of the Prison Law Strategy, Ford made his cuts to legal aid in Ontario. And so right after this huge document came out listing all the reasons that we need prison law advocacy, the prison law strategy was cut. So it doesn't exist anymore. And so if you're looking, for a creative way to potentially receive funding to do this work, parole hearings is one, and then there's also the test case litigation committee. And so this is exactly kind of what it says it is. It's for test cases. So you've got to really show that you have something very unique and different. And so that would potentially bring forward entirely new precedent. And this is quite a lengthy process, but it is one that is available through legal aid, and it's one of the only ones that's still available, and it does have a mandate to consider prison law cases specifically. So that is one way to fund some work. And then finally, I heard this from a lawyer recently who does prison law, and I really liked it. He said to Robin Hood it. And so if you haven't already kind of figured it out, prison law is very unlikely to be your bread and butter, your income. If you want to be a prison law lawyer and that's all you do, you're probably not going to make enough money to get by. And that's obviously strategic, and that obviously has a lot to do with the ways that our systems are developed, right? Where we provide support for lots of other folks, but not for prisoners. And it's not a coincidence that Black, Indigenous, and racialized folks are more likely to be incarcerated. And so what I would recommend, and what I've heard recommended, is this idea that you Robin Hood it. So you find an area of law that isn't totally cringeworthy, and you do that to make your money. So if you want to do labor, or if you want to do like plaintiff side civil litigation, or just find something that isn't intolerably, I mean, I'm sure there's lots of areas of law that aren't, but if you can find another area of law where you can actually make some money, and then use the money that you make from that to support, for example, like if you want to do like a claim, a negligence claim in civil courts, and you need to pay for that original statement, like find other ways to make money, because unfortunately the state that we're in right now, prison law just isn't going to do it unless you're doing class actions and you're at a huge firm. So I definitely recommend for law students who are considering this area of law, think about how you're going to make your money, because this most likely won't be it. So finally, just want to throw up some resources here. So the Toronto Prisoners' Rights Project and CPEP, last summer, we put together this resource guide. And so I have a link to it here. And I was going to list a ton of other resources, but I think the resource guide really encapsulates all of it. And so it's categorized specifically by areas where there are prisons and jails in Ontario. And then it has all the resources available in that area for folks. And then we also have the jail line, which Sahil spoke to already. And so recently in Toronto, the Toronto Prisoners' Rights Project opened up a jail hotline. And so I have the numbers for both provided here. And Rejan was just going to speak to us quickly about sort of the beginning and implementation of the TPRP jail line. Rejan, are you there?
I am here.
Awesome. Okay, I will pass it off to you to talk a bit about what's happening in Toronto.
Yeah, I'll be really quick. This has also been a phenomenal presentation, and just extending the gratitude that I've been seeing in the comment section on Facebook. So we have a community-run jail hotline, very much inspired by the traditions of jail hotlines that you see with CPEP, with folks like the Barton Solidarity Project, that there's a lot of other sort of deep history of jail hotlines in prison abolitionist organizing. So the dates that we have there are a bit outdated. Since we've launched the jail hotline, we've seen more people come through and volunteer to support, and so we've extended our hours. So we're actually open Monday to Saturday, so every day except Sunday, 9 to 11 a.m. and then 2 to 4 p.m. And there are volunteers who are trained, who have accesses to resources and support to connect folks to whatever kinds of supports you might need. Often the calls that we're getting is folks reporting things that are happening inside the jails, human rights abuses. So a lot of our work is calling the jail and flagging these issues and making sure that they know that people are paying attention and people are seeing what's happening inside. It's also just been a phenomenal resource for us to be able to ensure that we are hearing from prisoners about their demands and the way that conditions have degraded, both during COVID, but also just generally within prisons. The jail hotline is also completely free, so prisoners that are looking for advocacy, that are looking for referrals, information, or just general community support can call the line for free. We do really need community support to be able to continue to run the jail line, so we have a GoFundMe account that you can support. You can we'll maybe drop the link in the Facebook and the YouTube comment sections, but all of it is 100% community run. It's an abolitionist line, so we don't coordinate or work with the jail in any way, shape, or form, and we're really just there to be in the corner of folks, and so we can actually cover calls from all of the prisons or jails that are within the greater Toronto area. So that includes the Toronto South Detention Center, Toronto East Detention Center, Maplehurst, Vanier. I'm sure there's other jails that I'm missing, but if it's in the greater Toronto area and it's not long distance, then we can take calls from there. And then there's other folks as well that run jail hotlines, like the Barton Solidarity Project, which connects to the jail in Hamilton. So yeah, thanks for sharing time with us, and thanks for offering the support and guidance as always, and looking forward to the rest of this presentation.
Awesome. Thanks, Rajan. So I had some links here for some fundraisers to support, and I didn't include the Toronto jail hotline. So if Rajan can just add that in like he said he will. So please look for that in the Facebook and YouTube links. And again, I'll share this presentation shortly afterwards. So if folks want to make a donation to the Jail Line fundraiser here in Ottawa, please feel free to do so. And also, I'm just going to take a minute to talk about the Prisoner Emergency Support Fund. So this is a fund that was started last summer, sort of as COVID-19 issues were emerging and becoming worse and worse in prisons and jails. And so this is a fund that folks can apply to and receive a $225 stipend. And so this can go to folks who are incarcerated, who are in need of support related to COVID-19 conditions. And the application form is not that onerous. It's available online. But currently, although the fund has raised, I think just over $150,000, which is really amazing. So thank you to people who have donated. It's still in need of quite a bit more money to fulfill the funding requests that we've received. And so there's teams of volunteers. Everyone is working really, really hard to get through all of the applications and get the funds sent out. But we don't at this point have enough funds to meet the needs of the applicants. And so if folks are able to, we definitely encourage donations to this fund. So thank you to everyone who joined us. For lawyers who are watching this, please shoot us an email at cpep.action@gmail.com if you're interested in being added to our list of supporting lawyers. And this doesn't have to just include people who are interested or who are able to practice prison law, any sort of legal support is more than welcome. We have folks calling with all kinds of legal issues that need support, so please do get in touch. And we're also hopefully going to be in touch with the Law Society to have accreditation. So, so if you are a lawyer looking for that, please get in touch. And I'm going to stop sharing the presentation now and open up the floor to questions. So we'll give it a bit longer. If there's no questions, we can probably finish up. Okay, we do have a question. Just waiting for it to come through. Okay, so I have a question here. It says, it's about how to file a charge against a guard in a federal institution. And the question is, a criminal charge for abuse, what would the process look like in Ontario? So I think there's several different ways that you could navigate that. So specifically, if a guard is abusing a prisoner, how could you act? What sort of processes would you go through is the question. And this is with respect to the federal context. So like we said, there's a lot of different stages that you would want to go through to analyze what would best suit your client. This could include potentially a civil claim for negligence if the person is being physically abused and there's a physical harm that's been done to them that you could claim for. It could include a complaint using the grievance process in the federal institutions, which there's a link to. Now, if it's a criminal charge of assault against the guard, that's something sort of outside of the scope of what we talked about today. Generally speaking, seeking criminal charges is not something that we deal with because we're working under this abolitionist framework. But again, when we're dealing with guards, it's kind of a different area. So I would say the options available would be, for compensation, you want to look at maybe a civil claim. Also, depending on what kind of abuse they're facing, if it's someone at Vanier at the women's institution who's experiencing abuse by a guard who's a male, like that's particularly problematic and something that you might want to look at the Human Rights Code for a remedy. But I think it really depends on the specific situation and sort of what the person wants who's experiencing that.
And also, Lydia, just I think as well, like like if when an incident happens inside a jail, for example, the guards, the sergeants will ask you if you would like to press charges against the guard, and is your freedom to press charges against them and put in a statement. So you basically would be putting in a statement, and then later on, like, police officers will come visit you at the jail, and to go through that process. But I think that one of the first thing like folks should do, like, that are, even though that's something that I don't encourage, or we don't encourage personally, that folks should do when they want to press charges against the police, is to basically, like, at least, like, consult with a lawyer. And at least consult with a lawyer.
Yeah, thanks, Sohail. And I think it's also important to consider too, when you are someone's legal advocate, or if you're somebody who's working with folks who are incarcerated, to bear in mind like the repercussions that could have for them as well. As much as we'd like to believe that these are transparent processes that won't have any kind of retributive acts by guards, that's definitely not always the case. And so just want to make sure that folks are aware of that, and how to keep themselves protected.
I mean, like, when they put charges, like when they press charges, or like when they put a report or a complaint against a guard, like, guards would be calling them like rats, like insulting them, calling them names, so it's very unsafe for folks who are experiencing those things.
I'll give it another minute. I'm not seeing any other questions though, so I think we can probably finish up shortly. Okay, so I don't think that we have any questions, but just so that folks know, we'll be putting all the information that was provided today up on the CPEP website, and I think we can share it. We will share it on Facebook as well, and so you'll have access to all the links that we talked about. And do feel free to get in touch, and please also make donations to the funds that we talked about. And thanks everyone for joining.